Hi, welcome to North State Law. I'm Nick Dogle, owner and founder. Today I'm going to be discussing licensure application denials and recent legislation that was passed in September of 2019 that changed a lot of things. Those changes can be found on North Carolina General Statute 93B-8, but I'm going to get into a lot of those right here. I also have a blog post on the subject as well, www.northstatelawfirm.com. You can check that out there if you prefer to read instead of listening. So the main thing that was changed is regarding criminal record checks of licensure applicants. Let's say somebody has a DWI that was 5-6 years ago. That's the only thing on their criminal record. Well, prior to 2019 in September, a licensing board or state agency could look at that and say, well, we're denying your license strictly because of this DWI that happened 5 years ago. They can't do that anymore. They can only deny a license based on a criminal record if it involves a crime that has a direct correlation with the duties and responsibilities of that profession. Or if the crime is one of violent or sexual in nature. Now, those licensing board or state agency can look at and deny a license based on that. For example, on the duties and responsibilities portion of that part of the statute, if say for example, somebody is a real estate broker and they are required to have a trust account to have money come in, money go out, and they have been convicted of fraud or money laundering in the past, the real estate commission is going to look at that and deny the license based on that. There is also a part of the statute that was changed that says, you cannot be denied a license based strictly on moral turpitude. So that's kind of a subjective term, and that's a little broad. If somebody is denied on something that is a quote-unquote moral turpitude conviction, there's an appeal process for that. The appeal process encompasses both state agencies like the Real Estate Commission that I mentioned. It also covers all the licensing boards throughout the state of North Carolina as well. So they can't just look at the conviction, going back to my previous example of that DWI, and say, well, this is a moral turpitude crime, we're going to deny you the license based on this. Like, no, you can't do that. Now, that doesn't mean that you have to be granted a license even if you have a conviction. They could, a board could look at, everything all told when you do your application and say, all right, well, I'm looking at these references these were fraudulent references, or this didn't line up, or there was some other issue with the application, and they can look at that and deny you on that and the conviction if they want. However, just looking at the conviction and denying you based on that, unless it meets one of the other exceptions that I discussed earlier, then they can't do that. If that does happen, you have the right to appeal. That was part of the legislative changes back in September 2019. The prior legislation that was enacted in 2013, it had laid the groundwork for the changes to be made, but it had no teeth to it. There was no appeals process for it. There wasn't anything at all about the criminal conviction side of it, and being able to still get a license with certain criminal convictions on there. If you or anybody has been denied a license, a professional license in the state of North Carolina, either by a state agency or a licensing board, and they want to explore options, feel free to have them give me a call. It's 919-521-8810. They can also reach me, email nick@northstatelawfirm.com, or happy to have them visit our website, www.northstatelawfirm.com. I hope everybody has a great day, and I will see everybody later. Bye-bye.